Lordship, if Lordship permits me, I would like to make a mention for listing of a review petition, which Lordship had ordered about that income tax matter on the last occasion, for review of the order tomorrow, Lordship. At least the notice may go to the parties tomorrow. Obliged, Lordship.
May I please, Lordship? My lord, here there's a student, my lord, LLB student. His exam is scheduled for Friday, this Friday, my lord. Owing to medical grounds, my lord, he was admitted. He has undergone an operation, my lord, because of which, my lord, he was short of 10% of attendance, my lord. Now he has been debarred from giving the exam, semester exam. A writ petition was invoked, my lord, and it was dismissed, my lord. Therefore, my lord, kindly allow me to move an unlisted motion for tomorrow, my lord. Friday exam is Friday, my lord. 10% attendance, which can be condoned, my lord.
Why unlisted? You file it, it will be listed tomorrow.
Tomorrow, my lord.
Yes.
My lord. Obliged, Lordship.
From the daily list, item number 1.
To make that
Lordship,
statement in the paper, the leave granted to file and to list tomorrow.
I think this is income tax matter.
No, it's not income tax matter. It's a daily list. Lord, there is a delay of 111 days in filing the writ appeal, my lord. Learned single judge has directed that the recommendation of pay commission is to be applied to the employees of work charge establishment also, my lord. And that
This is Suchita Agarwal.
That's why, my lord, I am appealing Suchita Agarwal.
okay, sorry. I'm sorry, my lord.
That's why I said, my lord, income tax matter, my lord.
Yes.
May I start, your lordship? My lord, petitioner before your lordship is challenging the, my lord, notice issued under section 148AB and the order passed in pursuance thereof, your lordship, on the ground, my lord, that the proceeding which has been initiated on the basis of, my lord, search and seizure operation which was taken place in the year 2017, my lord, and thereafter Panchanama was prepared, and, my lord, after my reply, authority being satisfied, my lord, released my duality. That your lordship will find at page 108, my lord, annexure 3.
Where are you stationed, Mr. Counsel?
My lord, Guwahati, your lordship.
So why don't you do the matter physically?
My lord, as your lordship, my lord.
It is more convenient for the court. Unless there is great inconvenience faced by learned counsel.
My lord.
No, but have you given notice to the respondents?
My learned friend he is appearing, my lord, Mr. Chetia. As Chetia, my lord.
Lordship, I am appearing for SMN number 224, my lord. Income tax department.
So question arises for determination, my lord. In case of search and seizure, my lord, there is a provision section 153A, capital A, that I have quoted in the petition, my lord, that your lordship will find at page 3636.
Yes.
It says assessment in case of search or requisition. Notwithstanding anything contained in section so-and-so, in case of a person where search is initiated under section 132 or books of account, other documents or any assets are requisitioned under section 132A after 31st May day of 2003, but not on or before 31st day of March 2021. So since, my lord, after, my lord, sealing my locker, your lordship, no proceeding was initiated, and authority on page 108, your lordship, 108. Annexure 3, page 108, your lordship. administrative approval for release of seized assets in the case of Sri so and so, so and so. So and so Shillong, by later dated so and so, has submitted a proposal for release of seized jewelry, which was duly forwarded and recommended by JCIT range Shillong, by later dated so and so, so and so, wherein jurisdictional assessing officer, that is DCIT Circle Shillong, had recommended for release of seized jewelry items amounting to, my lord, amount is important, my lord, 43,65,200, maintained in the name of so and so. So in this connection, SSC has requested for release of jewelry items seized during search and seizure operation on 3/1/2018. In the report of assessing officer, which was duly forwarded and recommended by the range head, a search and seizure operations under section so and so was conducted by Investigation Director, New Delhi, on 3/1/2018 in case of Sri so and so at local number so and so, maintained by so and so, South Extension. During the search, jewelry worth rupees 61 lakhs 14,858 were found, out of which jewelry worth 43 lakhs 65,200 were seized and deposited in strong room so and so. Your lordship may skip over. Thereafter, your lordship will see in this case, in the same paragraph, last paragraph, you also will see in this case, no proceeding under section 153A or 153 were initiated. This is very important, your lordship. Srimati so and so, so and so, so and so have executed affidavit before notary Kamrup so and so, stating that the locker number so and so was jointly opened them and whatever contained in the said locker belongs to Srimati so and so. Thereafter, as reported by the assessing officer, range head, who is the assessing officer, no proceedings of assessment, penalty or interest is pending, and no existing liability is outstanding in respect of the SSC, Srimati so and so, under section so and so, the Wealth Tax Act, Expenditure Act, Gift Tax Act, Interest Act, etc. In view of the above, administrative approval is hereby accorded for release of seized jewelry in terms of the case of Srimati Sujita Agrawal. So my humble submission before your lordship is, authority being fully satisfied, released my jewelry, and my lord, no proceeding has been drawn under section 153A, which is, my lord, specifically meant for the purpose of, my lord, seizure of jewelry or goods, your lordship. The proceeding which is initiated on the basis of search and seizure operation, which was undertaken in the year 2018.
You have received the seized goods, the
I
jewelry.
have received, my lord. This is the, yes, I have received. After being satisfied, proceeding under section 148A was initiated, my lord, without no new material, nothing. There was no reason to believe, my lord, only on the basis that material was found in the 2018. And the authority himself is saying that they are satisfied. Thereafter, after obtaining prior approval, it was released. So in my humble submission, my lord, it is directly hit by section 153A. Since proceeding was not initiated prior to 2021, authority has initiated this proceeding, 110, page number 110, your lordship. Is, my lord, without jurisdiction, my lord, and my lord, at this stage, my lord, I think, my lord, department may like to file and proceeding, my lord, further proceeding make, this is my prayer, your lordship, may be stayed, my lord.
Lord, at this stage, my lord, notice may be issued, my lord. We would like to file our detailed affidavit, my lord.
After admitting everything, that page 108, that proceeding under section 153 has not been initiated, which is the prior condition in the case of, my lord, search and seizure. Only to, my lord, since it is barred by limitation, my lord, they have initiated proceeding under section 148 without fulfilling the preconditions.
Where is that section? 158?
My lord, that your lordship will see at page 3636. 153A, my lord. (153A), page 36. assessment in case of search or requisition.
Where is the time limit provided within which?
Here, your lordship will see in the first paragraph itself. No, there are books of accounts so and so document under section 132A after the 31st day of May 2003, but on or before 31st day of March 2021. In the present case, my lord, search and seizure was taken place in the year 2017. So it fall under, my lord, this period. And my lord, Honorable Apex Court and Delhi High Court, several decisions held that if the proceeding has not been initiated under section 153A, it attained finality. And my lord, proceeding initiated under section 148A, it was, my lord, quashed, my lord.
No, this is the date of requisition,
My lord.
2003 to 2021.
My lord, Panchanama was prepared in the 2018 itself, my lord, Annexure 3. Your lordship may kindly see Annexure 3. Page 95, my lord, Annexure 2, my lord, page 95. And date is, my lord, 3/1/2018. Date, it is given, my lord, at the bottom, 3/1/2018. I have given my statement. I have given every details. In fact, regarding jewelry, my lord, I have filed my return, and the authority being satisfied, released my goods, jewelry, on 4/3/2024, page 108.
Let him give an answer to it. They should not proceed any further to what it is. Yes, please take down. We formally admit this writ petition. Paragraph. A notice under section 148 capital A within bracket small b of the Income Tax Act 1961 is challenged in this proceedings. Paragraph. The prima facie case made out by the writ petitioner, made out by learned counsel for the writ petitioner, is that although assessment under section 153 capital A of the Income Tax Act 1961 was initiated against his client in 2017, comma, by an administrative order dated 4th March 2024, issued from the office of the Principal Commissioner of Income Tax, Shillong, bracket page 108 of the writ petition, bracket closed. Administrative approval was accorded for release, within quotation, for release of seized assets in the case of Srimati Suchita Agarwal, unquote. Outside quotation, bracket, the writ petitioner. Full stop. These assets had been seized under section 132 of the said act. After which the above assessment proceedings under 153 capital A were initiated. Full stop. No, proceedings under 153 capital A were sought to be initiated. No, right at the beginning, what you have written with regard to 153A? What sought to be initiated? After search and seizure operations, but after search and seizure operations were carried out under Section 132 of the Income Tax Act 1961 against the petitioner. Thereafter, then continuation of that. No, what have you done? Although then the prime. Right. You just arranged that.
Yeah.
That although assessment proceedings were sought to be initiated under 158(3)(a after search and seizure operations. But, yeah. Then full stop. Furthermore, it was stated in the said administrative order that no proceedings under Section 153 capital A stroke 153C were initiated. Therefore, paragraph, therefore, it was contended that proceedings under Section 147 stroke 148 of the said Act for the assessment years 2018-19 were not warranted. Paragraph. There is some merit in this prima facie case. Paragraph. In the aforesaid notice dated 5th August 2024, the petitioner has been asked to show cause why a notice under Section 148 of the said Act should not be issued. Paragraph. As an interim order, we direct that the petitioner will answer to the show cause.
We have already answered, my lord. I have already answered to the show cause, page 114.
Yes, it is submitted by learned counsel for the petitioner that the his client has already answered to the show cause. Paragraph. Considering the above prima facie case and the balance of convenience, we direct that no further action in furtherance of the notice under Section 148A of the Income Tax Act 1961 dated 5th August 2024 is to be taken by the Income Tax Department against the petitioner till disposal of the writ petition or until further order, whichever is earlier. Paragraph. Affidavit in opposition by when you can file your affidavit in opposition?
Lordship, 3 weeks may be granted.
All right. Affidavit in opposition by 5th February. The holidays will intervene in the meantime. 5th February.
Lord. My lord.
Affidavit in reply by 19th February. List this application for hearing on 24th February.
My lord. Deeply obliged, my lord.
Item number 2.
I'm obliged.
Yes, my lord. There is a continuation of delay application, my lord, in writ appeal of 111 days. Notice has to go to the respondents, my lord.
All right. This is a writ appeal against a judgment and order of a learned single judge. Now, this is an appeal from a judgment and order of a learned single judge in the exercise of his writ jurisdiction. Paragraph. There is a delay of how many days, Mr.
111 days, my lord.
111 days.
Yes.
There is a delay of 111 days in preparing this appeal. Paragraph, we direct that the respondent be noticed in the usual course and an affidavit of service service return report filed before the returnable date. Before the vacation or after the vacation?
After vacation, my lord, because this
All right. List this application on 5th February.
grateful.
From the main list, item number 1.
Mr. Banerjee, your presence here should be an impetus to others to make a physical appearance.
Not you, very kind man. Mr. Shah is also here. He's
Mr. Shah.
very busy person himself. No, that's not. Always a pleasure. Or four.
Why online? It's a beautiful place. Come and do matters physically.
I do very often.
Yes.
May I please your lordship? My lord, I just want to communicate. I'm appearing for respondent number 3, my lord.
Yes.
I'm on BC from Guwahati.
Okay.
State.
State.
Lord,
Yes, this
I
was-
very briefly introduced this matter on a previous
yes, you had
occasion.
started this matter. Yes.
Yes. Now, my lord, we have the Meghalaya Excise Act, my lord, which is something that the state of Meghalaya has inherited from my lord Assam. It was the Assam Excise Act, now my lord termed as the Meghalaya Excise Act in its application to the state of Meghalaya. My lord, the Act provides for a rule-making power under section 36, which I shall take your lordship to. And my lord, pursuant to these my lord rule-making powers, my lord, 2 rules were framed, amongst others. One is the Meghalaya excise rules and the other is the Meghalaya bonded warehouse rules. Now, my lord, a bonded warehouse is something that's permitted to be established, my lord, under section 16 of the Act. But my lord, what is a bonded warehouse? It is a warehouse, my lord, where my lord, goods, my lord, come in, stored, my lord, subject to payment of tax, and then, my lord, distributed to the retailers. Now, my lord, so far as the trade of liquor is concerned,
Yes.
my lord, the Meghalaya Excise Act makes provisions for, my lord, trade in liquor in the state of Meghalaya. And, my lord, so far as the bonded warehouse rules concerned, my lord, it provided for the establishment of bonded warehouses. Lord, what would happen is, my lord, that the bottlers or distillers whom I represent, my lord, as a body, of persons, bottlers and distillers would, my lord, on requisition from the bonded warehouses, of which, my lord, there were 45 in all, in the state of Meghalaya, my lord, they would requisition, my lord, items of liquor, my lord, which then would be imported into the state, stored in the respective bonded warehouses, and from there, my lord, after, my lord, discharging the bond, my lord, this would be distributed to, my lord, the retailers, from whom, my lord, it would ultimately reach the consumers. Now, my lord, for this service that the bonded warehouse was providing, my lord, a minimum, my lord, 8% commission is provided to them. Now, my lord, for example, in that case, my lord, if, my lord, a particular, my lord, bottle of liquor costs 1,000 rupees, my lord, the ex-bond cost, my lord, I say is 1,000 rupees. What would that ex-bond cost include? Ex-bond cost would include, my lord, my lord, manufacturing costs, and, my lord, the bonder's commission of 8%. And then, my lord, added to that would be, my lord, the excise duty, and then, my lord, the retailer's commission, and then it would reach, my lord, the customer. So let us say, my lord, the ex-bond price is 1,000 rupees. My lord, after, my lord, the imposition of, my lord, the relevant excise duty, and, my lord, the retailer's commission, maybe it is sold for, my lord, 1,100 rupees. Now, my lord, now suddenly, my lord, there is an amendment to the rules, my lord, which now provides that there shall be one central bonded warehouse. Now, the one central bonded warehouse now is given the power and the sole power to import, my lord, liquor into the state of, my lord, Meghalaya. And so far as this is concerned, it is thereafter, my lord, that central bonded warehouse which will distribute the liquor to, my lord, the bonded warehouses, from which it will then, my lord, go on to the retailers and thereafter the consumers. Now, my lord, there would therefore have to be number one, my lord, a purpose for establishing the central bonded warehouse, because, my lord, there were no complaints made, at least not disclosed, in the pleadings or on affidavits, as to, my lord, what was the deficiency in the manner in which, my lord, the trade in liquor was being carried out through the bonded warehouses. Now, my lord, today, if a central bonded warehouse is allowed to be established, in that case, my lord, the natural consequence of that is, my lord, the central bonded warehouse is one more, my lord, step in the process. And, my lord, the central bonded warehouse will also have to be paid its own commission. Now, my lord, therefore, we have now, my lord, the ex-bond rate, my lord, which is, my lord, a rate fixed by, my lord, the government, or, my lord, by the excise commissioner, which would now have to include A, the bottlers or distillers rate, then, my lord, the CBW rate, then the bonded warehouse rate, before it reaches, my lord, the retailers. Now, my lord, this cost would have to be absorbed by someone. My lord, either, my lord, this will have to be absorbed by me as the bottler or distiller, or it would have to be absorbed by, my lord, finally the retailers. Now, my lord, so therefore, my lord, there would have to be, my lord, some purpose in establishing this CBW. Now, my lord, what this CBW does is essentially now, well, it says that the importation will no longer be made by the bonded warehouses or the 45 several bonded warehouses that were in existence at the time when the rules were amended. The importation will now have to be made only by the CBW. Now, my lord, how does it make the importation? Previously, the practice was that, my lord, the bonders of different regions are directly in touch with the retailers of different regions. The retailers of different regions, my lord, establish as to what is the demand for particular brands of liquor of particular manufacturers. It is on that basis that, my lord, ultimately the bonders or the bonded warehouses place an order on the, my lord, on the distillers or, my lord, the bottlers.
CBW is central bonded warehouse.
Central bonded warehouse. And, my lord, the, my lord, retailer would determine, my lord, what is the demand for particular, my lord, items of liquor. Lord, that is, my lord, how the open market or the free market operates. Well, it is the consumer, my lord, who is the king. The consumer determines, my lord, as to what are the brands that will move, what are the brands that sell, what are the brands that have a demand. Well, they, my lord, really ultimately levitate their, my lord, demands to the bonded warehouses. Bonded warehouses, my lord, place their demands, which, my lord, translate into orders placed on the distillers or bottlers. Now, my lord, with the introduction of CBW, the bonded warehouses cannot, my lord, do this any longer. they must route their demands now through the central bonded warehouse. And the central bonded warehouse alone will now have to place orders on the various bottlers or distillers. This creates a monopolistic situation and also really creates the level playing field that was operating thus far. Why I'll tell you, Lordship.
No, bonded warehouses have been abolished.
No, bonded warehouses are still there.
Yes. But they are under CBW.
They are now under CBW. Now, one would then have to wonder why the CBW was required at all. We are looking at, a legitimate, objective of establishing the CBW. It would have to have, a good enough justification for its existence, particularly when, it will ultimately reflect on, the ex-bond rate or, on the retailers' prices that they pay for liquor. Number three, today now the question is, how do they determine as to what are, the goods for which, orders will be placed? Now, kindly consider a situation where a bonded warehouse goes to the CBW and say, I want 100 bottles of, let's say, Kingfisher beer. And at that point of time, ultimately, the CBW says, well, Kingfisher is not available at the moment. The bonded warehouse will not wait. It will, let's say, very well, tell me what you have available. I will take that. Because, the customer will not wait, so the bonded warehouse will not wait. And, so therefore, ultimately, it reflects on, my shelf, my production, and my, movement of, my goods. And ultimately, what it does is, it does not allow the market to determine the demand, but allows really the CBW, to, determine the demand for, goods and products, because, there is no mechanism established on the rules which, regulates this entire procedure or which acts as a check and balance. Now, here, so far as this is concerned, in such circumstance, there was initially, a query made. Now, if your Lordship will kindly, have a look at, one or two documents in the petition first. Please have a look at, page 46. This is how the amendment, to the, excise rules took place. On the same day, that's on 15th October 2020, there were two notifications by which, there were two amendments that were affected. One amendment was to the excise rules, and the second was to the bonded warehouse rules. May I show you, Lordship, first, the amendment to the excise rules, 15th October 2020, page 46 of the writ petition. May I just read page 46? This is a notification of 15th October 2020.
Yes.
Well, if your Lordship will kindly see, this of course is done, in pursuance of the powers conferred by section 36 of the Act, which I shall take your Lordship to. This is to amend the Meghalaya excise rules. Then I will kindly see item number 2.
Yes.
In principle, rules in the principal rules, in Rule 3, in Sub-Rule 2, for the word bonded warehouse, the word central bonded warehouse shall be substituted. And then kindly have a look at Rule 4A, amendment to Rule 4A. In the principal rules for the existing Rule 4A, the following shall be substituted, namely, central bonded warehouse shall apply import permit on liquor allowed for canteens, etc. Now, this is the amendment to the rule. It says, establishment of central bonded warehouses. Now, kindly come to Rule 40, page 43, which is the more important amendment here in our case. That's also of the same date, 15th October 2020, page 43. This is the amendment to the bonded warehouse rules.
Yes.
Well, this is also done in exercise of the powers conferred under Section 36 of the Excise Act. My lord, may I read this a little slowly? Please come to, my lord, the second, my lord, item. Insertion of new clause Roman 2A in Rule 2. In the principal rules in Rule 2, after the existing clause Roman 2, the following new clause shall be inserted, namely, central bonded warehouse means a licensed central warehouse where IMFL, beer, wine, BIO, my lord, IMFL is foreign liquor, Indian-made foreign liquor. My lord, this is, my lord, different from country liquor. This is a very important distinction that the Act makes. I shall, my lord, take your lordships to that. Central bonded warehouse means a licensed central warehouse where IMFL, beer, wine, BIO, etc. imported on prepayment of excise or ad valorem duty, import pass fee or transport pass fee, and literage fee are kept for eventual removal to bonded warehouses as provided for in the Meghalaya Bonded Warehouse Rules, the Assam Bonded Warehouse Rules 1965 as adapted by Meghalaya, and all its extent. Insertion of Rule 4A, new Rule 44. In the principal rules after the existing Rule 43, the following new rule shall be inserted, namely, license for central bonded warehouses shall be granted on the following conditions. 1. A license to establish and work a central bonded warehouse in the designated area. My lord, will kindly make a note of the word designated area. Well, a designated area would imply that it is only for a particular area in the state and not for the entirety of the state. But, my lord, here the application is made for the entire state of Meghalaya. So, my lord, a license to establish and work a central bonded warehouse in designated area on prior approval of government shall be issued by the Commissioner of Excise. Selection for license to establish and work a central bonded warehouse in the state shall be based on competitive bidding process, open to individuals, partnership firms, companies, etc. The base fee for a license to operate central bonded warehouse shall be 1 crore 50 lakhs or annually or as fixed by the government. Now, this is important again. The tenure of the license shall be for 10 years. The Commissioner of Excise, however, reserves the right to extend the period of tenure with prior approval of the state government for any additional period after expiry of the term of the license at the same or revised terms and conditions as awarded. So, my lord, contemplation is to, my lord, have a central bonded warehouse for a designated area for a period of at least 10 years. Then, my lord, may I request your lordships to kindly turn over and come to, my lord, page 44. I want to skip over, my lord, some of these rules. Serial number 8. The central bonded warehouse shall be eligible to supply only to the bonded warehouses located within the state. So, my lord, from the designated area, we come to the entire state. And here it made clear that, my lord, central bonded warehouses will be the only ones eligible to supply to, my lord, the bonded warehouses. The central bonded warehouse shall have the capacity to supply and deliver all the registered brands of IMFL, beer, wine, BIO, etc. to the bonded warehouses within 45 days for goods produced in the state and 60 days for goods imported from outside the state. So, my lord, the intention here, my lord, they will have the capacity to supply and deliver all registered brands, and, my lord, that supply will be made, my lord, within a 60-day period. So, my lord, if I today place an order, they should be in a position to, my lord, supply the goods to me within a period of 60 days. But, my lord, in reality, my lord, that never happens. If I place an order, I want, my lord, the goods immediately. Well, then, my lord, next, the central bonded warehouse shall have a minimum stock of all types of brands for 3 months at any point of time, so that continuous regular supply can be maintained for all bonded warehouses throughout the state. Now, what is the minimum stock? How will the minimum stock be determined? How will it be determined for a period of 3 months? How will then the stocking be done? What is the objective of this? Objective, if the object is to immediately make available particular brands to bonded warehouses, how is it to be achieved? There is no guideline. There is no clarity on this. Then 12, the minimum profit margin eligible for bonded warehouses on their sale to retail IMFL of and on licenses shall be 8% for IMFL brands only, except bottle in origin. So, bonded warehouses will be entitled to minimum 8% commission on the sales. So, the ex-bond price will have to factor in 8% for the bonded warehouses. Then the central bonded warehouse or ex-bond rates of all imported goods shall be subject to approval by the Commissioner of Excise during the course of annual registration of brands. On commencement of central bonded warehouse, the bonded warehouses shall lift all liquor from central bonded warehouse against the import permits issued by the Commissioner of Excise and cease to import directly from the company's bottling plants, etc. Now, this is the amendment with which we are concerned. Now, this, as a result, ultimately prevents the bonded warehouses, 45 bonded warehouses, which were determining as to how the market and the market forces would determine the trade, that is skewered, or I would say done away with. This ultimately leads to a monopoly of pricing. Now, so far as this is concerned, there are 3 things that are affected. A, the market approach, the pricing, and the impact on the trade in general, which was previously being determined by the market process through the retailers, the bonded warehouses, and then by the manufacturers and bottlers of liquor in the state.
No, market pricing, which is the third?
Market pricing is one, market approach is the second, and the level playing field, which was available on a free competition basis, these 3 things are affected. This is by reason of the unbridled power that is ultimately vested in the central bonded warehouse. Now, here, I may just, for example, as to how this will impact the pricing, when this was established for the first time, ultimately, there was a demand made by the respondent number 3, which is the central bonded warehouse. We were asked to file an affidavit showing us to how it really impacts us and the trade, which we did, which is the petitioners did, by an affidavit that was affirmed by one Prannath Kapoor on 14 September 2021. Now, so far as this affidavit is concerned, I would just like to point out, presently for your Lordship, here this discloses, amongst others, a letter that was written by the respondent number 3, which was chosen as the central bonded warehouse. If your Lordships will kindly have a look at the affidavit of 14 September, may I request that to be handed up to your Lordships, 14 September 2021. May I just read it out to your Lordships? Your Lordships need not be troubled right now. I'll just read out just one line. Page 11 of the affidavit. It's a letter written on 8th April 2021 by the CBW that was established. It says, as per clause 15 of the license conditions, because they were issued a license.
8th April 21.
8th April 2021.
Page?
This is page 11 of an affidavit, supplementary affidavit that was allowed to be filed by the petitioners on 14th September 2021. I'll just read it out presently, so that your Lordships are not troubled with the papers right now. Just one page I want to show. Well, this is what they write. Well, the CBW. We suggest that the cost card should be finalized within 15th April 2021 and should include a 25% margin, which includes 8% bond margin, paid administrative and miscellaneous charges. Further, we ensure to make payments of all goods sold within 45-60 days approximately. So, Malad, here, Malad, the CBW, Malad, immediately upon being established, Malad says that we propose to impose a commission of 17%. 17% Malad, for the CBW plus 8% for the bonded warehouses. Malad, they say that we suggest that the cost card should be finalized within 15th April 2021 and should include 25% margin, which includes 8% bond margin. So, well, the suggestion here is that, my lord, ultimately, this will have to reflect in the X bond rate, because they are asking, my lord, the bottlers or manufacturers to finalize the cost card. My lord, this is how, my lord, it would impact the pricing by at least 17%, which is, my lord, huge insofar as pricing of, my lord, these goods are concerned. Now, my lord, kindly have a look at, my lord, come back to the writ petition. My lord, please have a look at page 48. My lord, because this was proposed to be finalized, a sole entity was supposed to be finalized as CBW, my lord, through a tender process. My lord, the notice inviting tender is at page 48. Well, I'm not troubling your lordship with the notice inviting tender, just showing your lordship, my lord, that this is the notice that was issued on 17th November 2020. My lord, will just make a note of the date. This will be relevant. I shall tell your lordships why. And then, my lord, we'll have a look at, well, at page 50. My lord, this is the tender document. Again, I do not wish to really trouble your lordships with that. Well, finally, my lord, please have a look at, well, the special terms and conditions of the tender at page 54. Well, this provides in item serial number 7, special terms and conditions of tender, that the central bonded warehouse shall be eligible to supply only to bonded warehouses located within the state. So, my lord, ultimately, well, what was to be the designated area only is extended to the entire state of Meghalaya. Well, at page 54, serial number 7, well, a term of tender, central bonded warehouse shall be eligible to supply only to the bonded warehouses located within the state. So, my lord, ultimately, the whole of state of Meghalaya becomes the designated area, my lord, which was the amendment of the rule. And then page 55, serial number 9, the central bonded warehouse shall have a minimum stock of all types of brands for 3 months at any point in time, so that continuous regular supply can be maintained for all bonded warehouses through the state. Now, my lord, the intention here, my lord, one would, my lord, gather, is to have, my lord, a ready stock of all, my lord, available brands of liquor, my lord, on the basis of, my lord, their demand for 3 months. Now, my lord, how the demand is to be estimated, not provided. What would be the minimum ready stock, not provided. How is it to be determined, not provided. And, my lord, none of this is provided. We have, my lord, amplified this in separate affidavits. So, my lord, this is, my lord, what was there. Now, my lord, so far as this is concerned, immediately thereafter, my lord, if your lordship will kindly have a look at the license, my lord, which was issued to the respondent number 3 at page 60. Again, my lord, kindly see.
Mr. Goel is appearing for respondent number 3.
Mr. Mishra, I think.
Mr. D.K. Mishra, ma'am.
Mr. D.K. Mishra.
We are being led by Mr. D.K. Mishra, ma'am. He is a senior advocate to BC.
He's on screen.
He's on the screen, ma'am.
All right. He's for respondent number 3.
3.
CBW. And Mr. Modi, senior advocate.
For CWC.
Yes.
And the present license holder?
Yes, ma'am. That's the
The license holder is, my lord, respondent number 3. That's the CBW. Well, the license that is issued, your lordships will find at page 60. Well, I will request your lordships to kindly turn to page 61. Well, Roman 15. Again, the licensee shall not be permitted to issue, the licensee shall be bound to maintain such minimum stock of foreign liquors and spirits in the central bonded warehouse as may from time to time be fixed by the Excise Commissioner. Now, my lord, here, my lord, now the Excise Commissioner will fix. My lord, there is no notification till date of the Excise Commissioner as to how this is to be fixed. So, my lord, this is, my lord, at cross purposes with, my lord, the notification itself. Because ultimately the notification suggests that you will have to make maintain a minimum stock of all, my lord, international, my lord, of all IMFL brands on the basis of their 3-month demands without specifying as to how, my lord, this demand is to be assessed, as to how, my lord, the stocks are to be procured, how the stocks are to be maintained, and, my lord, how the stocks are to be made available to the, my lord, respective bonders or, my lord, different bonded warehouses. Now, my lord, so far when this, my lord, came to light, my lord, ultimately there were, my lord, representations made, my lord, by the Association of, my lord, Bottlers and Distillers, which your lordship will find at page 65. Will you kindly see, my lord, page 65. Well, this is the first representation made to the Commissioner and Secretary of Excise and Taxation Registration. You will also find the heading is Meghalaya Change in Route to Market. Our feedback and request. Well, we'll kindly see second paragraph. We have for reference your notification seeking creation of central bonded warehouse in Meghalaya, which will function as the sole wholesaler for all alcoholic beverages products to be sold in the state of Meghalaya, thereby creating an additional link in the route to market for alcoholic beverages in the state. The notification makes no mention of the reasons that warrant the introduction of this CBW in the supply chain. We can only assume that there are valid reasons for creating such a monopoly that will complicate and stretch the process and time for fulfilling consumer demand, apart from increasing the cost of operations and the logistics of supply. That this is a private monopoly complicates matters even further, as it could easily tend towards abuse of the CDW's dominant position, particularly with no perceivable government control. There have been instances in other states of the havoc and loss of image that private monopolies in this sector have brought to the governments in power. There is no clarity as to the services that the CBW will provide and the benefits that it will bring to the suppliers, to the government, to the consumers. It is only fair that the beneficiaries of the as yet indeterminate services should pay for such services. To amplify, if the creation of the CBW is for ease of government control on the supplies, then rightfully the margin should come out of government revenues. Alternatively, if the introduction of a CBW in the supply chain is to enhance consumer confidence in the genuineness of the products being sold, then it is only fair that the consumers should pay for the cost of this by way of all increase in costs. Creation of a monopoly, and a private one at that, with no evident government oversight, that is stipulation of CBW margins like down for bonders and retailers, is an undesirable move. This is particularly true when the state is seeking comparison of ex-bond prices in Meghalaya with contiguous states. You will appreciate that no other state has such a contradictory stipulation. Also, in no state does the trade margin go as high as 17% that the CBW representatives are attempting to seek from industry players, and that too for no commensurate services that our members can currently perceive. Then, my lord, there is a request, my lord, to provide clarity of the role and benefits to allow additional costs to be borne, etc. Then, my lord, this request is repeated at page 67. Well, I will not read this because, my lord, this says essentially the same things. What is now important is, my lord, the government's response that your lordships will find at page 70.
No, I believe this ceiling on profit, profit margin, prevents you from giving a cut to race competition.
Well,
Profit cut.
there are three things. Well, number one, my lord, so far as this is concerned today, well, you lot will find that, my lord, who are the petitioners? The petitioners, my lord, are the agglomeration of all the, well, distillers, bottlers, etc., who are otherwise in competition with each other. Now, my lord, they have come together because they want, my lord, the open market or the free market forces to determine their
Before
demand.
this, as I have tried to understand, the what is the CBWs?
Yes.
Assess the market, procured the materials from you, being bottlers, and then handed them down to the retailers.
No, CBW to bonded warehouses, to retailers.
No,
to
CBW is the bonded. No, not CBW. The bonded warehouses before CBW.
Yes. Well, before, my lord, there was a bottler,
Bottlers to
then bonded warehouses.
bonded warehouses to
Retailers.
assess the market, take it from you,
Yes,
and then give it to the retailers.
that's right.
Now it has to be routed through CBW.
Yes, and my lord, routing is done, my lord, on what basis, my lord, there is no clarity on that. Because, my lord, today, we are concerned with two things. We are concerned with, my lord, fair competition, so that, my lord, we can, my lord, pitch our products and reach it to the customers who demand it. And we are also concerned with the pricing of our product. Because, my lord, if the prices go up, the demand will come down. That is a natural consequence, my lord, for, my lord, brands which are not absolutely premium brands. My lord, premium brands will, my lord, determine their own pricing. But, my lord, otherwise, we are concerned with two things. My lord, our goods must reach the market. And, my lord, the demand for our goods must be determined by the consumers themselves. And two, my lord, the pricing must be, my lord, fair so that it does not eat into our, my lord, profitability, our costs, etc. Now, my lord, this was being, my lord, very well controlled, my lord, through the bonded warehouses. Because, my lord, 45 bonded warehouses were collecting, my lord, demands from the market based on what the consumers were looking for. My lord, translating them into orders placed on, my lord, the different, my lord, bottlers and manufacturers. And, my lord, they were supplying to the bonded warehouses who were then, my lord, supplying it, my lord, to the retailers, maintaining the 8%, my lord, commission. Now, my lord, CBW comes in. Now, my lord, the bonded warehouses are supposed to place their demands on CBW. I would presume that it is to be based on demands, my lord, of the market. My lord, what is the consumer need? What is the consumer want? And my lord, that is translated into orders placed by the bonded warehouses on the CBW. Now, but my lord, so far as this is concerned, the CBW is expected to have, my lord, minimum stock of all brands for a 3-month period. Now, my lord, the difficulty that has arisen primarily, I'll tell you, lordships, why.
And then under the new notification, the CBWD will directly deal with the retailers.
CBW will, my lord, directly, my lord, procure from the bottlers and distribute it to the different bonded warehouses. So, my lord, the bonded warehouses are not excluded. We are introducing one more, my lord, player into in the market, in the chain. And, my lord, without any discernible purpose. Now, my lord, we are looking at the discernible purpose. My lord, there must be an objective to, my lord, an amendment of a rule or notification. Now, my lord, there has to be a discernible purpose. The discernible purpose is what we are missing. Number one. Number two is, my lord, when there is a discernible purpose that is found, well, in that case, my lord, the purpose must be so regulated to, my lord, prevent monopoly, to prevent abuse, to, my lord, ensure that, my lord, the objective is ultimately satisfied. Now, my lord, how is the object not being satisfied? While saying that you will maintain a 3-month stock, is not said as to how you will determine what the 3-month stock is. But today, it says that the bonders will place goods on orders on you. You will give the orders on 60 days. Not, my lord, earliest by 60 days, latest by 60 days. Now, my lord, a bonder comes and says, I want these products today. And, my lord, the CBW says, no, I don't have ABC, you can take DEF. Bonder will happily take DEF and go because his customer will not wait. That affects, my lord, the demand for, my lord, products for particular, my lord, of my manufacturers and bottlers. And these are, my lord, what we had highlighted repeatedly. Now, my lord, there is no, my lord, clarity, there is no regulation, there is no check or balance. And, my lord, this your lordship will be astounded to find, my lord, this, my lord, CBW, my lord, which is ultimately awarded the license, my lord, that is established just a few days before, my lord, the notice inviting tender is issued. my lord, the notice inviting tender is issued, and my lord, the CBW, the respondent number 3 participates in the auction. Who is the respondent number 3? It is a partnership. Of whom? Of, my lord, people who are also manufacturers of, my lord, IMFL in the state of Meghalaya and are also bonded warehouses. So upstream and downstream supply are both being controlled. Now, my lord, today, if I am a manufacturer, a bonded warehouse owner, and also the CBW, I will naturally want my products to move in preference to the products of others. So, my lord, that will ultimately what will happen? Ultimately, my lord, today, if a bonded warehouse comes and says, give me 5 bottles of Kingfisher, I say, no, I don't have Kingfisher now, I have my brands. You can take them if you want. So, my lord, ultimately, it affects the demand for Kingfisher, and, my lord, pushes up the demand for, my lord, the local manufacturers, who are in turn also bonded warehouses, some of them, and who are now also the CBW. So, my lord, they control upstream and downstream both. And, well, that is something that is now established on record and, my lord, commented upon by this court in one of its orders. Now, my lord, when I, my lord, show this, when I make this representation, my lord, this is the response of the state. My lord, please have a look at page 70. My lord, I straight away take your lordship to page 71. Let paragraph 5, the main reasons for introduction of CBW are as follows. This is the state's justification. Paragraph 5. Well, this is the government's response. Well, for the first time providing the justification. There was no justification in the notification, no justification in the notice inviting tender, no justification in the tender notice. Well, at paragraph 5, it was observed that some bonded warehouses applied for a lesser number of import permits. Now, my lord, kindly see, some bonded warehouses, we don't know which, applied for a lesser number of import permits, we don't know how many, perhaps due to financial constraints. Well, also there's an element of, my lord, doubt introduced here. Perhaps due to financial constraints as their investment increased manifold after introduction of prepaid ad valorem duty, since most of the liquor companies would not dispatch and accept indents lesser than truckloads of products. Again, my lord, which companies, my lord, who have said that we will not, my lord, ultimately indent goods without truckloads being ordered, not provided. All the bonded warehouses are indenting goods individually, and to make up for the numbers for a truckload, they tend to order slow-moving brands, my lord, which is again not, my lord, clarified, leading to unnecessary piling of stocks, which at times becomes unwholesome, unfit for human consumption, and ultimately has to be destroyed in due time, causing losses to both the bonded warehouses and the state exchequer, affecting the growth of the industry. With the introduction of central bonded warehouse, any bonded warehouse will be able to indent any brand as per their specific requirement, which in turn would result in minimizing their investment with assured turnover, since the central bonded warehouse would be able to supply an assorted range of products in a single truck, which otherwise had to be procured truck-wise from different companies or locations. Now, this is very important. With the introduction of CBW, it would be easier for the government to exercise controls and monitor one entity in place of existing 45 bonded warehouses, and it also serves as a single point for collection of duties, fees, etc. levied by the government, thus helping in plugging the revenue leakages, if any, in the system. So, my lord, no revenue leakage has been found. And finally, if your lordship will kindly have a look at para 9. My lord, which is completely, my lord, wrong, that the creation of CBW does not entail any additional cost of operations to the existing tiers, that is liquor companies, bonded warehouse, retailers. the margins payable to CBW should be regulated purely on free market play. The government does not intend to regulate the margins for CBW as it would tantamount to interference with the market and price dynamics across various brands and types of liquor. The minimum margins for bonded warehouses are fixed to safeguard their interests based on representations made by them in this regard. And then, my lord, if your lordship will kindly turn the page. Paragraph 10, that by creating CBW, the government
Now,
has not...
Mr. Shah, what is the position? The BWs make a request to the CBW
Yes, now...
based on demand that you give me, that you say that I need this.
Yes. Now, my lord, let's say I am the bonded warehouse.
Yes,
I place an order on the central bonded warehouse.
yes.
The central bonded warehouse is supposed to, my lord, supply me the products within 60 days.
Directly or through bottlers?
No, through, my lord, I am a bonded warehouse.
Yes.
My lord, the retailer, my lord, makes it.
You requisition CPW.
And CPW
will in turn direct the bottlers to supply you.
That's it. Not to supply me, to supply to them. They will then supply to the bonded warehouses, who will in turn supply to the retailers.
Okay.
So, my lord, one more, my lord, link is introduced without any discernible purpose. Now, my lord, here, my lord, the interesting fact is, my lord, your lordship will kindly come back once to my lord page, my lord, 71, paragraph 9. My lord, paragraph 9, last paragraph. At page 71.
Yes.
That the creation of CBW does not entail any additional cost of operations to the existing tiers, that is the liquor companies, bonded warehouse retailers. Margins payable to CBW should be regulated purely in free market play. Now, my lord, how this will be achieved is nowhere, my lord, discernible from the, my lord, amendment notifications. Now, my lord, that there will be, my lord, a cost impact is obvious. Because, my lord, the CBW will charge its own commission as it has sought to do, my lord, on the representation that you should factor in your cost card a 17% commission for us. So, my lord, obviously, my lord, the prices will be affected, and this is a, my lord, wrong representation. And then the margins payable to CBW should be regulated purely on free market play. How? The CBW, my lord, then, my lord, what is the suggestion here? Well, the CBW then can, my lord, demand different margins in respect of, my lord, different products.
Yes.
Well, CBW then can, my lord, determine, my lord, different margins for different products. If this is, my lord, free market play, that is to determine it. So, my lord, let us say, they say that we shall take, my lord, 8% commission on, my lord, products which are our own products, because we are also bottlers. And we shall charge 25% for others. Where is, my lord, the scheme which regulates this? Where is the scheme, my lord, which provides for the check and balance? And, my lord, the representation here, margins payable to CBW should be regulated purely on free market play. But, my lord, the CBW ultimately, my lord, says that no, it's not the free market play. We shall ultimately, my lord, charge margins as we decide. And initially the representation was that, my lord, it will be, my lord, 17%. And, my lord, this in itself is, my lord, an antithesis of the free market. My lord, the free market, my lord, is something that will have to determine, my lord, its own demand. And, my lord, ultimately the pricing of different, my lord, products, which should not be affected by the margins that, my lord, the CBW decides to impose. Now, my lord, this is the representation. So, what is the...
Well, cut your profit margin to increase sales.
Yes.
If you like.
Yes. Because if I have to absorb the cost, it will cut my profit margins. If the consumer has to absorb the cost, then the, my lord, demands will fall. And, my lord, ultimately, my lord, this will affect, my lord, either the ex-bond rate or the retail rate. Now, my lord, what is the ex-bond rate? Ex-bond rate is something that the excise commissioner determines, which includes the bottler's rate, the cost of freight and transportation, the margin payable to, my lord, the CBW now, and the margin payable to the bonded warehouse, which is, my lord, fixed at a minimum 8%. So, my lord,
Earlier, the profit margin was not fixed.
no,
Now it is fixed.
no,
Now,
my lord, earlier also, my lord, the profit margin would have to, my lord, factor in 8%, my lord, commission to be paid by the bonded warehouse. Now it has to factor in 8% to the bonded warehouse plus whatever is to be paid to the central bonded warehouse. And we don't know how much they will charge. At one point of time, they say that factor this into a cost card at 17%. 17 plus 8, that is 25%. And, my lord, the justification here is that, my lord, we have observed that some bonded warehouses are ordering less. There is no empirical data provided either in this reply or in the affidavit that the state has filed. So, my lord, what is the basis of, my lord, this, my lord, presumption? They are saying that orders were being paid in truckloads, slow-moving goods were being ordered. My lord, no, my lord, data to support this. And, my lord, they said perhaps, my lord, this was leading to, my lord, slow importation of the goods into the state. And, my lord, it says, with, my lord, the introduction of CBW, what will happen? My lord, Roman 3 at page 71. My lord, it would be easier to monitor, my lord, a single point of tax collection or duty collection and help revenue leakages, if any. And for that, ultimately, you have to burden the consumer or the manufacturer with 17 or 18% or 19%, my lord, extra commission. Now, my lord, so far as this is
for
concerned,
example, earlier it was say 8%, minimum 8%.
yes,
So your rival say is charging 12%. You bring it down to 10 or 9. So you cut profit. You by the sale turnover, you increase your profit margin.
my lord, may I just,
Now, say it is 17. All right, if minimum is 17. So you can maximum give them 18. You can't give them less than 17. So if it has to be 18, it will overall increase your cost of production.
that's it. My lord, another way of looking at it is this, my lord. Initially, my lord, let us say my cost of production was, my lord, was 92 rupees. My lord, on that 8% minimum, bond, my lord, commission had to be paid, which would make it 100 rupees. So, my lord, the retailer would get it, my lord, with 100 rupees plus excise duty. Now, my lord, now what will happen is my cost of production remains 92. My lord, bonded warehouse commission of 8% is there, so it's 100. Plus, my lord, 17 rupees that is charged by, my lord, now, CBW, so it's 117. On that, my lord, excise duty and on that retailer. So, my lord, this additional 17 rupees is something that either I will have to bear, which will only reach into my profits, or the consumer will have to bear. One part of it. Secondly, my lord, so far as this, my lord, is concerned, as to 17% commission that CBW will charge, my lord, will it charge uniformly? Will it charge differently from different manufacturers? Here, my lord, the representation made by the government at page 71, at the last page is, the margins payable to CBW should be regulated purely on free market play. The government does not intend to regulate the margins for CBW as it would tantamount to interference with the market and price dynamics. Now, my lord, what this will mean is, my lord, CBW will say, very well, I shall charge 17% on brand A, 6% on brand B, 8% on brand C, 19% on brand D, and lord, that would affect, my lord, the market completely. Because that would mean the price of certain products would be, my lord, raise, the price of certain products will fall, and, my lord, this will affect the market dynamics altogether. And there is no basis provided, my lord, in the notification as to how this is to be regulated, controlled, what is the check and balance. Now, my lord, these are the representations that are made. Now, my lord, so far as this is concerned, my lord, what are the impacts that will be faced, my lord, that, my lord, the court initially wants me to put on affidavit. And when I file an affidavit to this effect, which your lordship will now, my lord, kindly take up, is the affidavit one from which I placed that, my
How
lord.
much more time are you likely to take, Mr.
Well,
Shah?
this will take a little time because, well, there's a lot of law to be shown, my lord. I have to show you lordship
It will
that.
not finish today.
My lord, it will not finish today. Your lordship has also kept tomorrow.
Tomorrow, your lordship will take.
Yes, there is no problem. A continuous hearing, there is no problem, Mr. Banerjee?
Tomorrow, my lord, yes, your lordship kept it tomorrow.
In terms of hours, how much you will take, Mr.
Well, at least 2 hours, my lord.
And
I'll take some time, depending on, I'll take.
And day after tomorrow, you will be here.
No,
Day after tomorrow will be difficult.
difficult for you. Your Lordship will tomorrow later, my Lord. Day after tomorrow, Your Lordship will.
So your Lordship has very kindly started the hearing of the matter, my Lord. We were not being able to get the matter.
No, it's no kindness. It is our duty, but then we have to also accommodate you and see your convenience. So if you can just abridge your submissions to 1.5 for reply, we can finish tomorrow, and the rest in notes.
But tomorrow, I'll need another day for argument, my Lord. Your Lordship will kindly accommodate me. This will take some time. I have to address also and show a lot of.
Then it is all right, Mr. Shah.
You will
finish tomorrow.
Tomorrow,
let me finish tomorrow. On the next day, I'll make my submission. I'll also take.
first matter tomorrow.
Yes.
I'm obliged.
Yes. And Mr. Banerjee, when will you, please do it before the vacation.
No, after the vacation, Lordship will not do.
We will forget it.
It will be difficult. Lordship will keep it after the vacation. Please, I have to, some personal difficulties. Lordship will kindly keep it up. Promise not to take more than 1.5.
It is our memory which
We have been very eagerly waiting for the matter to be taken up, heard and concluded. But when if Mr. Banerjee can, my Lord, accommodate all of us.
Some difficulty. I would really come
before the vacation.
just because I have some difficulty in the next 10 days. So Lordship will keep it immediately on reopening. I'll finish it.
Respond number 3 could, my Lord, although, my Lord, I would imagine the respond number 3.
I would like to argue before. It's the attack on basically on the state policy.
That is right.
So
Respond number 3, really have nothing to say. It is, my Lord, ultimately the state which has
State has to defend it. Respond number 3, it can, of course,
So
support.
after you will respondent number 3.
My Lord, Your Lordship will permit me to argue after him.
After 3.
Argue for the state first, then R3 will argue. Let me defend the policy, my Lord. Then after my learned friend will say whatever they have to say. On other aspects, my Lord, factual aspects.
All right.
We have been waiting, my Lord, on our challenge to the policy for 3 years. I can only request, my Lord, my learned friends to find some time, my Lord, so that the
As soon as the Lordship opens, my Lord.
By the end of January, it will be.
Lordship is opening whenever the Lordship will keep 2 days.
No, but you see to it.
I'll certainly try to accommodate my
It
Lord.
will be very bitterly cold at that time.
I have no difficulty, my Lord. I enjoy the cold, my Lord. I have no problem.
Mr. Shah, is it all right for you?
I will have to, my Lord, find time and, my Lord, the convenience to attend. But it's always a pleasure to come here, my Lord.
Already. All right,
As the
Mr.
Lordship said, it's a very beautiful place otherwise. So.
We are encouraging physical appearance here. Online is against the culture.
I'm
of
sure
our-
Mr. Shah could not have made this impact online, if I may.
I have never, my Lord, been, my Lord, one of the, my Lord, supporters of online appearances because, my Lord, it is, my Lord, the physical presence.
Every vocation, occupation, profession has its culture. Our culture is physical.
Well, I also feel, I know it's unfashionable to say that the interaction between the judge and the lawyer is part of the real sense of the profession and the beauty of the profession. And a flickering image on the screen can't really capture that interaction.
Hardly a substitute.
As I tell my friends, the difference between theatre and films. Yes, please take down. Mr. Jishnu Shah, senior advocate. Commences his arguments on behalf of the appellant, but does not conclude the same. List is appeal as the first matter in the list tomorrow
Petition, my Lord.
for the petitioner. To hear further arguments.
Obliged.
The bonded warehouses have independently filed a writ petition, which is item number 2.
So are we hearing both together?
Yes, together. Your Lordships are.
Appearing for the petitioner in that writ. Give that.
You are dealing with that.
Item number 3.
You see, the good, the bad, and the ugly. The right corner shooter, where each one is trying to shoot. That's what it reminds me of. Come here.
Yes.
May I please, Your Lordships?
Yes.
Lordships, on the last occasion, this court was pleased to allow us to file an affidavit of service effected on respondents 4, 5, and 6, Lordships, which we have filed the affidavit, Lordship,
Affidavit of service.
Lordships.
You're appearing for 4, 5, and 6, Mr. Mozika?
My lord, I'm appearing for one, my lord.
I'm for 2, Your Lordship. Clear.
I'm entering appearance for respondent number 4, 5, and 6.
Very good.
Your Lordship, I'll be filing my power in the course of the bill.
Yes, yes, do it. Move your appeal.
My lords, I would require some time, Lordships, to prepare the matter. I pray this matter may be listed next week, Lordships. I'll come prepared.
Mr.
I come after vacation, my lord. There's no such.
Lordship, after
Here is a challenge to the appointment of judicial officers, my lord.
Lordships.
And the petitioner participated in the process, my lord.
This is for admission of the appeal.
My lord. But only the notice has been served on the private respondent now, my lord.
Your writ has been dismissed.
Yes, my lord.
Lordships.
No interim order required.
No
No,
intervention.
Lordships.
We admit the appeal, you file paper books.
Lordships.
We admit this appeal from a judgment and order of a learned single judge in the exercise of his writ jurisdiction. Full stop. There is no scope of any interim order. Paragraph. We expedite hearing of the appeal, comma, dispensing with all formalities. Then, at usual order, paper.
My lord, the question of maintainability we had raised, my lord, so that way we kept open.
We admit the appeal subject to the question of maintainability.
Well, deeply.
Obliged, Lordships.
By 10th February, paper book. Hearing, 19th February.
Item number 4.
Yes.
My lords, an affidavit has been filed, Lordship, by the National Highways and Infrastructure Development Corporation. We received the affidavit yesterday, Lordships, on the status of the package 1 for the widening of the National Highway 40, Lordships.
This report is ready, Dr. Mozika?
But we have filed by affidavit. We filed yesterday. my lord.
Is the work proceeding at
Work is proceeding, my lord. And in the affidavit, we have indicated, my lord,
pace at which
is at the desired pace, my lord. My lord, one aspect.
Yes, Dr. Moses,
My lord.
here the work is not proceeding as, as desired.
My lord,
You may say it's, it's progressing, but it is affecting traffic, it's affecting people.
my lord, here what happened, my lord,
Request them to speed up.
but I'll do that. I'll ask them to expedite the matter.
what is the report, Dr. Mozika?
My lord, the report primarily we have stated, my lord, that for any infrastructure project, my lord, under the Forest Conservation Act, the executing agency is required under the law, my lord, under the Forest Conservation Act, to compulsorily a forest equivalent area of land is in a non-forest land, my lord. So for that purpose, we have already spent a huge amount of money, my lord. We have acquired the land, handed over to the state government. We have also paid the cost of raising plantation in that, my lord, to the state government, my lord. And this is in terms of the notifications issued by the Ministry of Environment and Forest under the Forest Conservation Act, my lord.
And moreover, my lord, on the project site, my lord, wherever, once the project is completed, wherever space will be available, my lord.
In the adjoining area?
No, my lord, the forest land, there's a forest land bank, my lord, designated by the state government. And we have acquired the land in that area, my lord, in West Kassis district. My lord, lots of, I'll just point that out, my lord, page 10 of the affidavit, my lord, lots of kindly sees. This is 3 crore 34 lakh rupees. In fact, 3 crore 87 lakh rupees for raising the plantation, my lord. And additionally, we have spent about may I refer to para 6 of the affidavit at page 3, my lord.
The trees have already been felled.
My lord, the PIL was filed basically for 103 so-called heritage trees, my lord.
That is also felled.
So by the time the PIL was filed, my lord, 64 trees were already felled, my lord.
And so here you have said.
And now all 103 trees have been felled, my lord, pursuant to the orders by this honorable court, my lord.
So before we passed our order, it was
yes,
felled.
yes, my lord. That is why we
it was not told to us. We said no felling of trees till.
My lord, the 39 trees, your lordship, in the last order directed not.
But at that time they were felled.
They were already felled, my lord. And as regards the progress of the work, my lord, 32% of the work is completed by now, my lord. We have stated in para 9.
They had made 106 trees.
PIL was filed in respect of 103 trees, my lord.
100.
103 trees.
Okay.
But actually, in the entire 16 hectares of land in package 1, there are 5,044 trees.
Yes.
But PIL was only concerning those 103 trees.
Yes. In this public interest litigation, an order was sought from this court to prevent felling of 103 trees, comma, stated to be of great value while building the national highway from Shillong to Dauki near the border of Bangladesh. Paragraph accordingly, by our order dated 7th November 2024, we had called for a joint report by NHIDCL and the state government regarding their proposal for afforestation. In the area around the comma, or inverted comma, quotation, first package, unquote, of the highway. Paragraph. Today, Dr. N. Mozika, learned Deputy Solicitor General, appearing for National Highways and Infrastructure Development Corporation Limited, takes us through the affidavit affirmed on 2nd December 2024 by his client, the relevant paragraphs are inserted below. This you don't have to take copies of the sanction annexed here to. Somewhere over that you write, it was not pointed out to us that at the time of passing our said order, the 103 trees had already been felled by the authorities. Further to earlier orders of this court. Paragraph. In view of the above, we dispose of this public interest litigation by passing the following order.
My lords, if I may be allowed to interject, Lordship, there's a reference, Lordship, I would like to place before this Honourable Court as to the orders passed by this Honourable Court, Lordship, in 29th of...
This is only 103 trees, right?
Lordships, the initial grievance of the petitioner was regarding the unregulated felling of trees. But as per this Honourable Court's orders, the scope of this matter had been widened to overlook the entire construction and widening of the...
No, this is none of the business of the court to interfere in administrative work. 103 trees, that's all. Then the court should replace the ministry and sit in the secretariat.
Bow down, Lordship.
There is a limit to which public interest litigation should be confined to. We direct that the respondents jointly and severally shall ensure that the afforestation work promised, no, the afforestation work referred to in the above paragraphs of the affidavit of NHIDCL is strictly carried out. Next, construction of the highway completion of which is long overdue. Should proceed with expedition. Complying with the earlier interim orders of this court in this litigation and in accordance with law. How long will it take to complete it?
My lord, here, the entire road is divided into 5 packages, my lord. We are concerned with package 1, which starts from Shillong for about 15 kilometers or so. So now I was discussing with my brother if the entire thing should be, it's a very important highway. My lord,
from Shillong to Dow.
but the difficulty we are facing, my lord, in package 2 and 3, the villagers are obstructing because of the alignment, my lord. They want a different alignment of the road. And that has not been resolved by the state government till now, my lord.
In fact, we have been sitting and persuading. Land has been acquired. Compensation has also been paid to villagers. And 1 or 2 villagers are obstructing, my lord. So, and they have filed 1 writ petition also before the learned single judge, my lord. But there is no stay. There is no restriction.
You add one where learned advocate general submits. No, with due dispatch, full stop. At this stage, Dr. Muzika submitted that the highway is in what is it? Passage. Huh? 5 packages. And that some obstruction was being faced in continuance of the construction. Full stop. Learned Advocate General intervened and said that all steps are being made to facilitate construction. Full stop. Land has been duly acquired. Full stop. In spite of that, some elements are obstructing the construction and have also filed cases in court. Full stop. Considering the submissions, we direct the respondents jointly and severally and in collaboration with each other to ensure that this very important highway for the state is constructed, is completed as early as possible. Complying with the interim orders passed by this court earlier and in accordance with law. That's
grateful, my lord.
Obliged.
Yes, for the next item.
Item number 5 and 6.
5 and 6, my lord, it will take some time. Your lordship may have it after vacation, my lord, these appeals.
By consent?
Well, otherwise, it can be taken up after vacation. But only thing is that there is the construction work is pending and it is not getting settled.
PIL? No, it's not a PIL. It's a tender, my lord. And successful bidder, lowest successful bidder was granted the contract, my lord, which was challenged by second lowest bidder, my lord. And there were about 8 bidders because it was a work contract in which the...
Yes, we heard that.
Yes, my lord. Your lordship has heard it briefly, my lord. I am ready for my friend is before...
It could be before vacation, after vacation. Your
Whatever
convenience.
my friend says, I am agreeable, my lord.
Lordship, I had stated on the last occasion, Lordship. That's why it was listed today that I'll be not, but it is, this matter needs urgent dispatch, Lordship. We are ready, Lordship. It can be continued today, tomorrow.
Today, tomorrow,
Tomorrow I
is
have
also
difficulty,
granted
Lord.
fixed. No, tomorrow is not possible.
Lordship, it's not a big matter, Lordship. It can
So
be
your
had
lordship
today
may
only.
have it on next week, my lord, because the 10th or 11th, your lordship's subject to your lordship's convenience. Or whatever because I'm entirely in the court's hand.
When are you available?
Lordship, I have stated, Lordship, after the vacation, but it'll be too long. It will be too long
So you give a date, when do you want?
not 10th. Lordship, can it be on 17th, Lordship?
17th is the last working
December,
17 is last working day.
last day.
last day.
You can't come to a court of law with your diary,
Lordship.
with your diary full.
Lordship, I have been continuously appealing, only this time I have said.
16th you are here.
16th? 16th, your lordship may have it.
All right. This is an appeal.
Lordship.
Appeals.
All right, this appeal for hearing on 16th.
Item number 7.
Okay.
This is the last one. Yes.
May it please your lordship. Lordship, this is for admission, your lordship, a state appeal, your lordship.
Who's for the respondent?
Lordship, last time, your lordship, they have entered appearance, your lord. Mr. Sen.
Mr. Sen had appeared.
Lordship, yes.
And none appears for the respondent? Although the appellant is represented by learned counsel, we are only adjourning it for the day. Tomorrow.
Lordship.
This appeal is adjourned for the day. Advocate on record for the appellant will inform respondent's advocate on record. Of this order.
Lordship.
Informally, just telephone him.
All right, Lordship. Nothing.